Hey, sorry about that, everybody. I was having some technical issues there. All right, but welcome to this Saturday's edition of the Legal Hour with Mark Wallace, your host and facilitator of the People Show. Of course, every Saturday we are joined by Circuit Court Judge Leonard Murray, who is also a candidate for the appellate court. And so we're going to be talking with him as he join in with us momentarily. Of course, he's on the campaign trail, so he is always moving around. So we'll be waiting for him to come. But in the meantime, let's certainly talk about some other issues. Early voting is underway. And so you can go and you can early vote at any of the early voting sites. If you have any questions about early voting, you can go onto the Chicago Board of Elections website, and you also can put in all of your information there, and it will tell you who your representatives are, state representatives, state senators, what beat, what district you're in, your ward, your judicial district, all of those areas. If you put your information in at the Chicago Board of Elections, they have a mechanism there where you can just put your information in, your voter information, put it in, and then you put your name in, your address, and it tells you exactly who it is that you represent. So I'm going to give you an example of who, what that will be. So I'm putting all my information in now, and you put your address in, and you got to put all the information in so that you can get the information. So I'm going to submit it, and then they will submit it. Now, sometimes yours may be differently, so they'll pop up what it is. So you click on it, and then it'll tell you. It'll tell you your name to make sure that you're registered to vote. So you want to make sure you check your voter registration to make sure that you are registered to vote, because you could have been purged from the voting rolls if you hadn't participated in an election in 3 years. So make sure that your voting registration, your voter registration information is up. So it'll tell you what your voter status is, whether it's active and good standing. So you certainly want to make sure of that. It'll tell you what your city precinct is, your district information, your United States congressperson, your state senate district, your General Assembly representative, your judicial subcircuit, your county board district, your board of review district, your CPD, your Chicago Police Department district. So it'll have a list of all of that information in there. So there's a wealth of information on there, and it will tell you where your primary polling place is should you not go and vote early. And it also has a list of all of the early voting districts. So go to the Chicago Board of Elections. It has all of the information that you need there to help you navigate through any questions that you may have relative to voting. So you want to make sure that you do that. And also, there are some key things that I have been talking about. Very key things. The Illinois primary elections for us in Illinois is really our general election, because most of what you vote for locally, whether it be in the judiciary, whether it be for a state office, whatever those offices are, our election is generally the primary election, because whoever wins in the primary election is generally the person who is going to win in November. So November 5th is the actual election date. So that's generally what happens. So generally what happens in the primary is it. So it's important that we go out and vote. And there are 3 areas that I am calling for us to vote. One is a protest vote against the Illinois State Supreme Court, based on what they just did in terms of recusing themselves from taking action on a petition put forth by the ARDC, and the 4 of them decided to recuse themselves from taking that up, and thusly that allows for a convicted criminal to continue to practice law and not lose his license. Ed Burke, who is convicted of 13 or 14 charges, number 1. Number 2, we need to make sure that we support the opponent to Larry Rogers Jr. in the 3rd District at the Board of Review, who has been giving huge tax breaks to wealthy property owners for a couple of decades that he's been there, and saddling us with that debt. Number three is what has been happening with Speaker Chris Welch and mounting this campaign against Mary Flowers Jr. He and Derek Curtis, who is the alderman of the 18th Ward, and some of the unions, they're putting $1 million in that race. If you are in Mary Flowers' district, go support Mary Flowers so that we send a message to Chris Welch and to the unions that you don't determine our representatives for us. All right. So, but I'm going to be talking about those later on today at 3 o'clock. David Orr is going to be joining me for a special podcast at 3 p.m. So make sure that you tune in for that. All right. Right now, joining me now is the current circuit court judge, Leonard Murray, who joins us every week for the legal hour. How you doing, Judge Murray?
Good afternoon, Mark. Doing well.
All right, great. Thanks for being here. All right, so last week we left off, or didn't leave off, but there was a question that was raised last week that one of the viewers had raised about bankruptcy as it relates to parking tickets and fines and that sort of thing, whether or not parking tickets could be eliminated through a bankruptcy, whether it's a Chapter 7 or Chapter 13. And you said that you would find out more about that and provide us with the an update on that. Were you able to get that information for us?
I was. So the current state of the law And the reason I hesitated to provide a response last week is that I thought there had been a change in the law with respect to eliminating City of Chicago parking tickets through bankruptcy. And indeed, there had. So uh, you can no longer discharge City of Chicago parking tickets via a Chapter 7. Now, with Chapter 7 is a situation where you walk away from debt that is, in fact, dischargeable. Uh, uh, by virtue of the filing, you get a discharge order at some point that allows that. Uh, you can put it in a Chapter 13 payment arrangement, though, which is essentially is a repayment arrangement in bankruptcy,
Hmm.
where you put all your debt in the bankruptcy petition, and uh, the court then determines what percentage of your debt is dischargeable based on your assets. And in some instances, as little as 10% of your debt has to be repaid, depending upon the particular factual scenario that you're involved with. So that is the current state of the law, that you can no longer discharge parking tickets in a Chapter 7 bankruptcy proceeding. Um, but some of it is possible to be discharged in the Chapter 13 petition.
All right, so it can be reduced at least, so you could be relieved of some of the
Yes,
debt through a
yes,
Chapter 13,
right, correct,
up to as much as 90%.
correct.
Okay, all right. That's good information to know. So if you have a lot of parking tickets, does that include other fines, municipal fines, whether it be grass fines, all of those cutting fines, that sort of thing? Does that include those fines as well, or building violations?
I did not look at that issue, Mark, so that'll have to be for the next show. But
Okay,
specifically focus on whether or not parking tickets, since there's such a wide swath of us who have
okay,
those.
okay,
Uh, um, um, but I will push the envelope a little further and get the answer to that situation as well.
okay. I think your camera has zoomed in that we can't see you. There we go.
I'm
Okay,
sorry.
all right,
Yeah.
all right, okay,
That,
all right.
that, that, that
So
was the cameraman, which was me, that screwed that up.
okay. All right. Okay. Very good. All right. So let's talk a little bit about the appellate court. You're serving right now at the Circuit Court of Cook County in the housing division, and you're the supervising judge there, and you're a candidate for the appellate court. Let's talk about what the appellate court is, what the appellate court does.
Yeah,
Um,
sure.
and who goes before the appellate court?
Okay. Well, by rule of the Supreme Court, which essentially is law, uh, any final order from a trial court in the state of Illinois is appealable. And there are also certain situations where even an interlocutory appeal can be taken of certain issues. But let's focus on what happens usually, and that is a case gets adjudicated from beginning to trial. After the trial is over, uh, assuming all issues have been covered, then that becomes a final order, which means that the entire controversy is decided, for or against you. If it happens to be against you or even for you, it is possible to seek review. It may well be that even if you have a favorable outcome, you might believe that it was not favorable enough. So, just a quick example. Maybe the finder of fact, and the finder of fact can either be the judge or jury, decides that your relief should be $50,000. You believe it should be more. So you could appeal the issue as to whether or not that $50,000 uh, uh, award is adequate based on what the facts of the case are. If you believe they are not, then you can appeal that verdict or that decision. Uh, and of course, if you lose the case outright, if you are the defendant and there's a $50,000 uh, jury verdict or court determination entered against you, that is appealable. If you believe that you should not have been found liable for whatever the alleged offense is, breach of contract, personal injury, what have you, then you have a right to seek review of that decision. The operative question or issue is whether or not the finding is a final order. Appellate court jurisdiction is based solely on the issue of whether or not there's a final order. And in fact, uh, uh, you as the litigant don't have the right to determine whether or not it is a final order. The appellate court has the right to determine their own jurisdiction.
Okay. And what? So, what is the cost? What is the cost for someone who has a case that is in the lower court that's been ruled, and they want to go to the appellate court? Do they have to have an attorney to represent them at the appellate court?
They do not. They can represent themselves. There is a cost of filing. It's nominal though, in terms of what's out of pocket. And it's also possible to seek waiver of that filing cost from one of the appellate court justices. So if you are challenged economically, you can seek a waiver of those costs from the appellate court. Um,
And go ahead.
uh, the, but the other part of the process, though, is that uh, the parties in an appeal are either referred to as the appellant, which is the party that is bringing the appeal, or the appellee, which is the responding party in the appeal. So, as the appellant, um, you then are obligated to file the record on appeal, which essentially is everything that happened at the trial level. The clerk's office at the trial level typically charges a fee for that effort. Uh, it's a function of what work is involved. Um, but it is also possible if you're an indigent person and don't have the wherewithal to come up with the cost for putting together the appellate record, it is possible for you to seek waiver of those costs as well. Because as the moving party on the appeal, meaning the person or entity that filed the appeal, it is your duty to file the record. So you must seek that the record be prepared by the trial level clerk's office, and then once it is prepared, then it must be filed with the appellate court. Now, in the era where we are, where so much of what happens at the trial level is electronic, uh, um, it is possible uh, that the the what it takes in order to prepare the record is much less than it used to be many years ago. So I don't know that those costs have been reduced as a virtue of the fact that um, um, the electronic uh, record keeping system that's in place now in most places um, that don't cost as much. But in any event, the appellant is required to seek preparation of the record and also the filing of the record with the appellate court.
And the the appellate court is what is a person appealing to the appellate court? If somebody is going to the appellate court, what is it that they are appealing for at the appellate court level?
Okay, they, well, the issues that could be appealed, for example, um, let's take a run-of-the-mill car crash case. Let's assume it's a rear injury. So it could be whether or not you were negligent, which led to the collision occurring. So you can appeal that issue, whether or not you were negligent based on the facts and the testimony, or uh, um also uh, the amount of damages that are awarded at the trial level. You can also appeal that number. So any issue that occurs in the trial court is appealable, and ultimately the question of guilt or innocence is also appealable.
Now, and is that um, so? Once you've had the trial, can the and if the person, whichever side, is not happy with the decision, are they allowed to provide any new evidence that was not presented in the trial?
No, you can't present new evidence, but you can seek review over whether or not evidence that you attempted to proffer should have been admitted and used as part of the trial. So if you have to submit it and make an offer of proof during the trial, if you receive a ruling that says that's inadmissible, you have to make an offer of proof of what would the evidence be and what you believe it would tend to show if it was received. But to preserve the issue for appeal, you must always offer the evidence at trial. Um, and that gives the appellate court the ability to review whether or not the evidence that you sought admission of should have been admitted at the trial.
And
But
would
you
the
have to make the offer. If you don't, you've waived that issue.
and if you've made the offer and you've waived that issue, so you can include that in consideration for your appeal. Um, and the appellate court, um, if they feel as though that evidence that you have submitted would have made some sort of significant in the outcome, would be determined. If they rule that it would not have made any significant outcome, does the appellate court make that also that determination?
Yes. So the question that you pose sets up this scenario. So let's assume that they conclude that the evidence should have been admitted at the trial level but was not. So the issue in their mind then is whether or not the failure to admit that evidence would have changed the outcome. If they believe it would have not, they would deem it to be harmless error, and therefore they would affirm whatever occurred at the trial level. If they believe it was not harmless error and could very well affect the outcome, then they have to send it back for a new trial. And
Okay.
that's why knowledge of the rules of evidence and preservation of the issues at trial is so important. Because if you don't preserve the issue, uh, even if it's a winning issue, then you can't raise it at the appellate level.
Okay. And do they also have people at the appellate level that, or assistants at the appellate level, filing of the appellate level, that assist an appellate in completing their documentation as they do in the lower court?
Well, let's go back through the mechanics of what an appeal looks like. So first of all, in order to preserve the appeal, you have to file a notice of appeal, and you must, at the trial court level, meaning the clerk of the trial court, uh, and that must be done no more than 30 days of the entry of the final order. Now, if you miss that deadline, then it's still possible to go directly to the appellate court and ask for leave to file that late notice of appeal. But the circuit court is no longer legally obligated to accept your notice of appeal, or if they do, it is subject to being stricken as being not filed timely. So let's assume that you file your notice of appeal timely. That then sets up certain timelines that are required for other things. So the first thing is a docketing statement. And when you talked about a cost for filing an appeal, that would be the instance where it could trigger a cost to docket the appeal. Years ago, it was a relatively minor amount. It was like $20 or something along those lines. I don't know if that cost has increased. That's a question maybe for next week as well. Um, but it was a minimal cost to file an appeal. Uh, After you have filed your notice of appeal and you file your docketing statement, then timelines come about for filing your opening brief. Now, your opening brief is where you, as the appellant, would set forth the issues that you have on appeal, uh, uh, that you want the appellate court to consider, and then uh, why it is. Hold on 1 second, Mark. Would you like to come across the street and see the clinic? Yeah, I'm on a podcast, so we're done at 2. Okay. 2:03. All right. Excuse me, I'm at an event for Congressman Davis at Solvent
Okay.
City. That's where I'm participating in the podcast this afternoon.
Okay. All right.
But in any event, so as the proponent of the appeal, meaning the party prosecuting the appeal, uh, you have two burdens. One of going forward, meaning putting the issue on, and then secondly, the burden of proof, meaning you must prove that the issue that you raise should be decided in your favor. You have to convince the appellate court of your side of the case. Uh, so that you begin to do in your opening brief. And in that brief, you set out what you believe the issues are, and then you make your argument. You also have to cite to uh, um, locations in the record where the issues that you're raising can be found. So that you raise this issue about whether or not you could bring in evidence post trial. You cannot, because it will not be part of the record. Now, it is possible sometimes, and this is rare, where you can ask to supplement the record, where for some reason there's something that was missed when the clerk put the record together. So if in fact it should have been part of the record and it was not, you can ask for leave to supplement the record by motion, in demonstrating and sustain your burden of proof on why that 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 evidence, that document, could be a transcript, should have been included as part of the record. But in any event, you refer to issues present in the record by page and line where these things are present, if need be. After the appellant files their brief, then it sets up the timeline for the appellee, who is the respondent on the appeal, to file their briefs. Now, it may well be that in some appeals, the appellee doesn't believe that it's necessary to file a brief because of the issue being so straightforward, or that there's nothing raised in the appellant's brief that desires to be responded to, and they can merely set forth a statement such as that as part of their appeal. Um, um, in something concise, and it's not uh, very very elaborate. Um, so, and then finally, if and when the appellee files its response brief, if you will, then the appellant then has the right to file its closing brief, and that's because, again, you've got the burden of persuasion on the appeal. So you get the last chance to say um, that the trial court was wrong and what occurred was not consistent with the evidence and the law. So that's your last chance to make that argument. Now, I had this question raised to me yesterday on a Mark. I hate to tell you, but I'm not exclusive to you. But I had this question raised on a podcast that I was on yesterday, and that is, do parties appear before the appellate court? The only instance
Well,
in which,
you preempted my questioning, because that was my next question: is
oh,
are there
okay,
oral arguments before the appellate court?
there are, but there's no absolute right to do so. It's within the discretion of the appellate court in terms of whether or not there's a need for an argument. It may be that there's certain issues that are just so straightforward um, that no argument is required. Hold on again, Mark.
Mhm. Judge Murray is at another event, so of course he is on the campaign trail. So we are doing this weekly legal hour with Judge Murray as he is
Yeah.
on the campaign trail. So
See you.
at
Yeah.
times he will
So,
be interrupted. So
yeah.
we make those
Yeah,
provisions. Okay.
Congressman Davis had an event here that was put on for him by the family of Prince Asiel.
Oh,
Uh,
okay. You're
so
right there on 75th Street.
Yes, I am.
Okay. All
Got
right.
a very good turnout.
All right.
Very moving event. Uh, but in any event, yeah, there is no absolute right to appear on your appeal in the appellate court. They make that discretion in their judgment, that decision rather in their judgment. It's at their discretion. So if they conclude that they can decide the case without argument from the parties, then they do that.
So
It's encouraged.
that would be typically if in fact the appellate, because it sounds like with the briefs that are provided to the justices, that they may have some further questions for clarifications that they would like to know, and they may ask. Would they ask for oral arguments or ask for the litigants to come in, or is this a petition that they put forth?
Uh, Mark, uh, I hope that is in fact the mindset that they follow, but I'm not sure. I can just tell you that, for example, this last round of election cases that went to the appellate court, there was no oral argument. They decided them essentially on the record. So,
Okay,
yeah.
and largely,
Gator Bradley wants to say hello to your audience, by the way. He said,
all right,
Mike Wallace.
Hey, man.
all right there. How you doing, Gator?
Man, trying to make sure we put this judge where he's supposed to be.
Or absolutely, right there on the appellate court.
You know, yeah.
We
That
gotta
young
do.
lady think because she got all that green on, she'll be better than him.
Well, listen, we know better.
Right.
We know better.
Right.
We know better. So we got to do all that we can to
Oh,
make sure
hey,
that
man,
we elevate
look,
him.
man, we going to.
All
But
right.
we know him better than anybody else.
Absolutely. Well,
You know, see, you still got your grade. I cut my grade because it was coming out uneven.
Yeah. All right, brother Gator. All right. Okay.
Back on.
Yeah.
So yeah, this last round of cases decided that were appealed. Um, I don't believe there was any oral argument that was directed by the appellate court.
Mm-hmm. All right.
They decided it based on the record.
Okay, so largely what the appellate court does is that they look at the record, and then they look at the argument that the appellate is making, and they're essentially saying that the lower court, meaning the judge in the lower court, made some rulings that, for all and purposes and intents, prejudiced the outcome against them.
Yes.
That were incorrect.
Yes.
In their view.
Yes, and even if they believe the outcome was incorrect, I'm sorry, the particular ruling was incorrect. They may deem that it would not have mattered in the ultimate outcome, and therefore call it what's called harmless error, and therefore affirm the underlying outcome of the case.
Right. So, in other words, in layman's term, if the judge made a ruling that was a wrong ruling about admitting some evidence or omitting some evidence or an objection, or sustaining it, even if that was an error, whatever that error was, it would not have changed the outcome in the case.
Yes. That's why it's important who sits on the court. What kind of experience do they have at the trial level?
Hmm.
Because if you have folks who don't have trial experience, significant amount of trial experience, then they may well not appreciate uh, that an error has occurred, and not only reach the wrong outcome with respect to that issue on appeal, but essentially deny a party their right to due process and justice, uh, what has occurred in the litigation that they're involved in. So experience is critical for the appellate level because you're reviewing what trial court judges do all the time. So if you don't have significant experience practicing as a lawyer and or functioning at the trial level as a judge, um, then there's a steep learning curve for you getting to the appellate court. And I don't know that any of us want a judge to preside on our case on appeal who does not understand what the process is and also does not understand what the law is.
Very critical. And speaking about due process, I'm glad you pivoted it there because that was to my next thing. There are a couple of instances where someone has said that they're in foreclosure. They're still in foreclosure. It has not been fully adjudicated, meaning that it is not going to a public sale, or it has gone to a public sale and it has not yet been confirmed by a judge to review that case to make sure that due process has been properly completed and therefore affirms or denies the affirm, but it hasn't. But what has been found is that can a bank send a property preservationist to change locks to enter a property that is in foreclosure that has not been fully adjudicated? Do they have the authority to do that?
Well, uh, until the bank becomes the owner, and that would mean that the foreclosure process is complete. And in addition, part of that process would require that the foreclosing court has given them an order of possession as well. Um, they're still a stranger with respect to that 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 property. So they don't exercise any dominion and control over it until, in fact, they do have dominion and control over it. So it would seem that if that's not the case, that their action was premature and not lawful.
So if that is the case, and that has been proven to the court, could the confirming judge, because the confirming judge is different from the actual judge who presided over the case and issued the foreclosure judgment, but could the judge that is issuing the confirmation, could they dismiss that case? Could that potentially be grounds for dismissal of that case and having them to start over?
Yeah, probably not. Uh, Now, it is actionable in terms of an injury, if you will, or at least a interference with property rights as such. So it's a tort. But I don't think that they would grant dismissal as a sanction for essentially a trespass. I don't think that's likely.
So somebody could go and prove damages before the confirming court.
Yeah, that's not likely going to happen.
Mhm.
I may have missed your question.
Well, the question was, can somebody go before the affirming court, confirmation court and ask for damages, and could that judge award damages? Do they have the powers to award damages at that level?
Yeah, hold on one second, Mark. I knew your dad. Prince? Yes, absolutely. And I'm involved in the African Festival every year. Yeah, that's you. Yeah. Actually, I'm putting on a festival.
Yeah. Again, folks, he is in the middle of a campaign himself, and then he's at another event for Danny Davis, and I'm sure that people are walking up to him, talking to him. So while he is engaged in that, the question that I'm posing. So the question that I posed to you, yeah.
Mark, I'm not sure. That that there are two judges involved in the foreclosure. I thought one judge handled it from beginning to end. You're suggesting that they have a judge who enters the judgment of foreclosure, and then there's a different judge who does confirmation?
Yeah, sometimes that does happen. Sometimes it does happen.
All right. Well, yeah, there may be some. There may be some procedures up there that I'm not aware of, but it was always my experience that the judge assigned to the case would take it from beginning to end.
In most cases, that is correct. In most cases, you're correct. But on the rare cases, they may have a substitute for whatever the reason may be on that particular case. But I guess the question would be let's assume that it is the same judge. But does that judge have the right to impose sanctions, or does that judge have the power to award damages to the defendant, even though the defendant is being foreclosed?
Yes, it would require the filing of a pleading by the aggrieved party to bring the situation to the court's attention. It might be in the nature of a counterclaim, where you would allege the fact that an agent for the mortgagee has entered the property without authority, could have damaged the property, or exercised dominion and control when they did not have it, and that's a tort, and it can be actionable.
Okay. All right. Because I know a couple of people have brought those to me, which I thought was rather surprising. But they, did raise those questions. And I know of one of them who did go to their confirmation hearing, and the judge at the confirmation hearing continued the case because he wanted to know more about what had happened. So I know that they're considering I guess further evidence in that case.
Yeah. Now, the only sort of adverse action, sua sponte action by a judge that I'm aware of, it happened in a case that I have, a foreclosure case that had actually been filed in federal court. And some mortgagees will file cases if there is what's referred to as diversity jurisdiction, meaning the plaintiff and defendant are not in the same territorial state. Then, because the amount of controversy normally exceeds the monetary limit for federal court, they will file in federal court. Now, I happen to have a situation, this is many years ago, where the mortgagor was going to redeem. He had sent, his sister was going to come up with the cash in order to redeem. So they appeared at the sheriff's cell, which was conducted by a special master, if you will, in order to bid at the sale. And it happened to be a lawyer. So they went to this lawyer's office, downtown Chicago. They were there prior to the scheduled time for the sale, waited about 30 minutes beyond the sale time, and finally, and when they arrived, they've been instructed by staff of the lawyer's office that the sale was going to occur out in the hallway. outside their doors. So they waited until about 30 minutes after the scheduled sale time. There was absolutely no activity whatsoever. Not their case or any other case occurred. And finally, about 30 minutes later, they go in and say, um, "We've been waiting here since before 12 for a scheduled sale at 12, and nothing has occurred." They were told by uh, that staff person that the sale did occur. And they said, "Well, how did the sale occur?" Because we've been waiting here since before 12 because we intended to bid on this property and could not and did not. So this person came to me for representation after the fact because uh, I had never experienced that situation where a scheduled sale did not occur. Because most of them, for the most part, are done by the sheriff of Cook County uh, in cases filed in state court.
Mhm.
But as I mentioned, this case was filed in federal court. So so I instructed this person to go back to that office, uh, uh, get a description of the person that they were told, given instructions for participating in the sale. Then I put together a motion to challenge the sale in federal court, and I went to I went down, and this was in the Dirksen building down 219 South Dearborn. Um, I went down um, to prosecute the motion and alerted the judge's staff that I was there, and they told me the judge has already ruled on your motion, and I was stunned um, with that response. So I said, "Well, what was the ruling?" So then,
You do know who I am, don't you?
yes, I do.
Who am
Hold on a second, again, Mark. You're
Diane, son?
yes, yes,
How you
yes,
doing?
yeah.
I know, I know.
Yeah. And so what the judge did, he not only voided the sale, but he dismissed the case
Wow.
because
Wow.
the selling agent was someone that was selected by the mortgagee.
And
So
not the court.
they right. So they imputed that bad conduct to their principal.
So was that case dismissed and they just had to start all over again, or was
Right. They had to go back to square one.
wow.
He
Wow.
dismissed it as a sanction for that um, inappropriate conduct on behalf of the principal of the mortgagee.
Right. Right. So it does happen. It does happen.
Yeah.
So
Rare,
as
but yes, it can happen.
right. So while we're talking about foreclosure, because I know that it's a very intimidating um, uh, proceeding for most people. Court is intimidating for the average person, but on foreclosures, so the in the Chancery Division is really a court of equity, right? So
Yes.
the court is really not interested in a person losing their property if they can demonstrate some way of remedying whatever that problem is. So they're not just there to blanket for on behalf of the bank. They certainly want to try to see if there are ways to mitigate that situation without the person losing their property. Is that correct?
Right, because Illinois. If you look at the pattern of law in Illinois, it really attempts to prevent people from becoming homeless. Both in landlord-tenant court and also in foreclosure court, because the state then, as the protective last resort, then would have to step in and provide some sort of security blanket for those folks who face that peril of being evicted ultimately. So one way to accomplish that one in landlord-tenant court, you're given time to try to cure um, a mortgage. I'm sorry, a rent default, if you will, after notice is served. And likewise, in foreclosure court, there is a mediation process that the court put in place, particularly as a result of COVID. And many people were so challenged economically because of loss of jobs and even diminished uh, uh, work opportunity. Um, so they put in place this mediation process to see if ultimately the mortgagor would have the ability to cure the default in some fashion over time so that they could preserve their homes and also avoid possibly being homeless.
All right. Yeah, some of these terms people they get confirmed. So what the judge is referring to when he says mortgagor, that means the borrower, the owner of the property. So you are the mortgagor. If you are the owner of the property, you're the mortgagor. The lender is the mortgagee, the person who provides the financing for the property. In the last few minutes that we have left, let's shift over to election law. You've represented a few people in who are on the campaign, and a few people who are currently on the campaign. Can you talk more about that?
Sure. Well, probably 20 years ago, I represented Larry Rogers, current member of the Board of Review, in an election contest, post-election administrative matters, and then ultimately a legal challenge case that was filed in circuit court over the fact that he prevailed over one of the Shaw brothers for the Board of Review spot that he currently holds. So it was an interesting and fascinating process. I had done some election law before that, but this process was actually less election law meets civil litigation. I did depositions at the county jail over persons who were involved in administering and allowing detainees to vote. Because even though you are detained um, in the county jail, your rights to vote have not been um, taken away yet. That occurs only upon conviction. So pretrial detainees do have a right to vote, and the system does attempt to facilitate the exercise of their franchise. So in any event, Shaw uh, raised a challenge as to whether or not the voting process at county jail was in fact according to law. Uh, we conducted depositions at county jail, and after the and adversity took up my whole summer. And after the depositions occurred, we commenced trial in the circuit court. At that time I worked with two other lawyers, Rich Means, who we unfortunately lost a number of years ago. He was a very good election lawyer and a great guy, and also Matt Delort, whose vacancy on the appellate court I am seeking. Um, we commenced trial in September, and I handled the first week of trial. So over the weekend, I got word through one of my co-counsels that the Shaw had agreed to give up that battle. So that first week of trial, which I handled exclusively, was enough for them to decide not to pursue the claim any further and to abandon it. So that propelled and secured Larry's victory in the primary for his current position of being commissioner on the Board of Review. Also, Joy Cunningham, who currently is a candidate for Supreme Court, she sits there now by appointment. I represented her when she ran for appellate court a number of years ago. I can't tell you exactly when it occurred now, but uh, that was an interesting situation as well because her margin in the primary was 500 votes. So we then went through the administrative process of recount challenges and so forth that a uh, that the losing candidate has a right to administratively, and ultimately that challenger also gave up the battle over whether or not there was anything in terms of vote count or otherwise that could sway the election in his favor. I again was part of the same team. Matt Delort and also Rich Means. We were the three lawyers who represented Joy in her win um, to the appellate court, and of course now that propelled her um, to the Supreme Court.
All
So
right. So you are representing. Actually, there are three people who are running for office: Larry Rogers Jr., Cynthia Cobbs, and Justice Joy Cunningham. Cynthia Cobbs is going to be with me in the 3 o'clock hour, so we'll get a
okay.
chance to learn more
Well,
about Cynthia
yeah.
Cobbs.
Well, my involvement with Cynthia is that after she became a judge, she did a tour in Landlord Tenant Court where I was sitting at the time, and she has publicly credited me with teaching her landlord tenant law after she became a judge.
Right. Very, very capable and qualified judge at the appellate court level. Really should be on the
Yes.
Supreme Court, but that's a whole nother conversation.
Yeah.
All right. We just got a couple of minutes here, so I want to have you to talk about your race. And those of you, you can look and you can see the header right behind me that Judge Leonard Murray. And so go ahead and talk a little bit about your race and sending people to the polls to vote for Judge Murray.
Well, Mark, I particularly appreciate this opportunity to reach your audience. But I have been a judge now for nearly 17 years. I am the supervising judge in what's referred to as housing court, but essentially what we do in my division is we deal with health and safety issues that pertain to real estate. So all the real estate in the city of Chicago, part of suburban Cook County that's unincorporated. Uh, we also sit as a reviewing body for administrative review cases that come from the city's administrative hearing section. In fact, we handle more cases there than the appellate court does for appeals. We handle about 2,000 cases a year on administrative review. Um, so I am seeking the Matt Delort vacancy. My punch number is 135. Um, I think my 17 years, nearly 17 years plus my experience as a lawyer, uh, uh, make me more than capable to sit on the appellate court. I was slated as an alternate by the Democratic Party back in August, but I knew at that time that it was very unlikely that there were going to be 4 additional vacancies on the appellate court, meaning 8 vacancies existing at one time. In fact, it is unheard of that there are actually 4 vacancies existing at the same time.
Mhm.
So I decided to give it a go. Obviously, if they slated me, apparently the party at least must have thought I was qualified. So I think that speaks to the, the security blanket that the public can have in terms of my capabilities to sit on that court. So thank you for this opportunity. It's always a pleasure to be on your show, and I look forward to next week. And I'll have the answer to that broader question about whether fines imposed by the city for building code violations and the like are dischargeable in bankruptcy.
All right, folks. Listen, that's going to do it for us this hour. Make sure that you go to the polls. Early voting is underway. You can go to any early voting polling place, and you can cast your ballot. And make sure that when you go to, don't be in a hurry. Vote for Judge Murray. Make sure you go to the end of the ballot and punch 135. He is more than capable, more than qualified, and we need to have that kind of experience and that kind of legal acumen at the appellate court. So let's make sure we support him for the appellate court of Cook County. All right, Judge Murray, thanks so much. Now, listen, how long is that event going on for Danny Davis there?
I think it's wrapping up. I think it was
Okay.
scheduled to go from 12 to 2. So I
Okay.
think it's near completion.
All right. Okay. Very good. All right. Well, listen, say hello to the congressman, and I'll let
I
you get
shall.
back to your campaign, and we'll talk next week. Thanks so much.
Okay. All right. Thank
All
you,
right.
Mark.
Okay.
All right.
All right. All right, folks. Listen, that's going to do it for this week's Legal Hour. And of course, Judge Murray, who is on the ballot, and of course, I am supporting him. Judge Murray married my wife and I, and he has just been a good friend, and he's a excellent judge. Very, very capable, bright mind on the bench, and we could use that bright mind elevated to the appellate court. So, coming up at 3 o'clock, we're going to be talking with another sitting appellate court justice, Cynthia Cobbs, who is probably one of the most talented, one of the most qualified people in our judiciary. She should have been on the Supreme Court, but because of what I call dirty politics, she's not there. But she is serving us and serving us well at the appellate court level. We want to make sure that she is re-elected for the seat where she now resides on the appellate court. So we're going to be talking with her at the 3 o'clock hour. So make sure that you tune in for that interview with Justice Cynthia Cobbs at 3 o'clock right here on Facebook Live, Twitter, formerly known, well, X, formerly known as Twitter, Instagram, and on YouTube. So we thank you very much for being here with us on this hour of the Legal Hour, and we will see you right back here with Judge Cynthia Cobbs at 3 p.m.